Good evening, everyone. So, today's session is polity, right? So, as part of this session, let us discuss a topic which is related to juveniles in India. Why is the topic of juvenile justice system is in news recently? Juvenile justice system. Juveniles. Juveniles in India. Juvenile justice system in India. Why is it in news? Recently, there is a issue going on in Gurgaon. In Gurgaon, a murder of a child, school-going child has happened. That has again reopened this issue of juvenile justice system in India. So, who is considered as a juvenile? Basically, who is a juvenile? Below 18 years. So, a child below 18 years, is he considered a juvenile? Yes. India? India? Offender who is below 18 years of age is considered a juvenile. Is it true? Is it true? So before considering who is a juvenile, what kind of criminal justice system that we follow up in India? What kind of criminal justice system do we follow in India? Reformative criminal justice system. So when it is reformative criminal justice system, reformation means to transform that particular individual from an offender to a normal man and release him into the society so that he is retributing for whatever mistake he has done. So that is the kind of criminal justice system we follow. So in this criminal justice system, the law, which law are we following in offending any individual? Which law talks about the criminal justice system in India, which is punishing for the crimes done by any particular person? IPC, Indian Penal Code. So which sections of IPC talks about? Which sections of IPC basically talks about juveniles? Is there any particular sections in the IPC that talks about juveniles? Yes or no? There is some section called as Section 82 of Indian Penal Code. Section 82 of Indian Penal Code says that, what does it say? What does it say? What does Section 82 of the Indian Penal Code tells? It says that any offense which is committed by any individual below the 7 years of age should not be treated as an offense. If a certain child has committed any offense and if that child is below 7 years of age, that should not be treated as an offense. That is what Section 82 of IPC says. So if a child below 7 years has committed any offense, what does it mean? Is that child aware of the nature of the crime that he is withholding? No. So the nature of crime, he is not aware of the nature of the crime. He is not aware of the circumstances that led to this crime. And he is also not aware of the consequences. What are the consequences that he is going to face by committing such an offense? So the intellectual mind of a particular person will not be developed till certain extent of age. What do you mean by intellectual gaining of mind? Intellectual maturity. We call it intellectual maturity. What is the right age as per psychology that any person to attain that intellectual maturity? Above 18 years. Most of the psychologists presume that in recent times, whatever a person, when you compare it with the older generations, a decade old generation and the current generation, whatever a person who has attained 21 years of age, that generation person is equivalent to 14 years of age in this generation. That is what the psychology says. Within 14 years only, by age of 14 years only, the intellectual maturity, the people, the children are able to get what 10 decades old generation could achieve in 21 years of age. So that is the equivalent number which was put forth by psychologists recently. So it was almost equated to 14 years of age. So now when someone is committing any crime who is below the age of 18 years, will that person be treated as an offender or he has to be treated separately? He has to be treated separately. What does the sections, the legal system in our India say? What does it say? Educating them. Can everyone be treated equally? The people who are committing some offense, they are unaware of the nature of crime they are committing. They are not aware of the circumstances which led them to, even they might not be aware of what is going to happen. If I motivated someone to do something, he might go and snap someone. That is also an offense. But is he intellectually matured and is he witnessing or is he realizing the circumstances? What are the consequences that he is going to face because of such heinous crime? Is he aware of it? When that person is not aware of it, then he should not be treated as an offender. He should not be treated as an offender. That is what the law says. Even the United Nations Convention on Child Rights even prescribes 18 years as the permissible limit for any child to be considered as a matured individual. So people below 18 years of age should be treated as a child only. He should be treated as a juvenile only. And the age limit is different for both male and female again. For male candidate, it is 16 years of age, whereas for female, it is 18 years of age. Below 18 women and above 16 male, if they commit a crime, they have to be treated as adults. That is what the recent amendment which was brought within the legal system, criminal justice system. So again, what about this section 83 of the IPC, Indian Penal Code? We have seen what is section 82 of the IPC. It says that a child below 7 years of age should not be treated as an offender. What about this section 83? What does it say? What does it say? Irrespective of your intellectual maturity, if the person is below 7 years and committed an offense, he should not be offended for that crime. Whereas this section 83, it mentions an age limit of 7 to 12 years of age. 7 to 12 years. This is below 7 years. Whereas this is talking about 7 to 12 years of age. Any child who is in between the age bracket of 7 to 12 years and if he has committed any offense, then his intellectual maturity needs to be taken into consideration. When I say intellectual maturity, whether he is doing that act or crime with a sound mind or not, whether he is aware about the nature of the crime, whether he is aware about the circumstances which led him to commit such an offense, or what are the consequences by committing such crime that I am going to undergo. If he is not aware of all these three aspects, then he should not be treated as an offender. Even he is more than 7 years of age. In between 7 to 14 years, 12 years, even if he has committed an offense, if his intellectual maturity is very low, then he is not liable for the offense. That is what the Indian Penal Code prescribes under this criminal justice system. So, in a nutshell, So we are talking about the act of a child. So act committed by a child below 7 years of age. Below 7 years of age. Is he liable for the offense? He is not liable. So an act committed by a child from 7 to 12 years. Is he liable for the offense? Yes or no? Is he liable? If he is a mature intellect. And here it is immature. So in which case he is liable? In which case? If he is a mature intellect and aged between 7 to 12 years, then he stands liable for the offense? Mature individual stands liable for the offense, whereas immature child will not be treated as an offender. Yes. So that is the duty. Who is the competent authority to decide whether he is aware of it or not? Who is going to? So that is what? A committee will be set up. All the juveniles who were treated, they will not be treated on equal terms with the adults. They have to undergo certain preliminary examination, which is conducted by a board. That board is known as Juvenile Justice Board. He has to undergo some preliminary examination by considering all the surroundings he has grown up, the society he is living in, the circumstances which has made him to commit such an offense. All these will be put into scrutiny. Then only it will be decided whether he is a intellectually matured child or intellectually immature one. Based on that, his punishment would be decided. So now, all this forms genesis, all the rules which we are talking about with respect to all these juveniles has its basis with something called as United Nations Minimum Rules for Administration of Juveniles. That is the convention. From that convention only, all these provisions were taken. In short, they are called as Beijing Rules. Beijing Rules. These are the rules which were prescribed by the United Nations, which typically addresses all the offenses which were committed by the juveniles. These are the international conventions which was put forth by the United Nations. These are named as Beijing Rules. What does these Beijing Rules include? It says that whenever a juvenile is considered as an offender, he should be tried differently from that of adults. He should not be treated like an adult. He should not be treated, or he should not go through the same legal process which is prevalent in that particular country. He should be treated with different set of rules and regulations. So that is the first rule which is incorporated in the Beijing Rules and Regulations. Second thing, it says that the age limit for considering such a child should not be as low as possible. The age limit should not be as low as possible, because it is typically very impossible for a child to be intellectually mature at such lower ages, at such lower stages of age. So the age limit which is prescribed should be on par with the intellectual or the maturity level which that person is gaining. That is the second rule which is incorporated in Beijing regulations. And the third one is, all these juveniles who are convicted of this offense should be treated separately, and they have to constitute a separate shelter homes and should not be kept with that adults who have committed the same offense. Because by keeping both of them side by side, you are victimizing this child even more to commit future offenses. So they have to be separated from the adults. They have to be provided certain shelter homes which are exclusively meant for these juveniles, and all the vocational training, skill development, all the nurturing skills that a person who is below the age of 18 years should undergo, all those facilities should be provided to that juvenile. All the schooling has to happen. Their sports has to be taken care of. Their nutrition facility has to be provided by the respective schools, juvenile schools, whichever were established. all these things, all these requirements and criteria needs to be met by those juvenile justice boards. These are the 3 rules which were incorporated under the Beijing regulations. So now we have something called as another international convention, which is known as United Nations Convention on Rights of Children. United Nations Convention on Rights of Children. This is the major convention of 1989. United Nations Convention on Rights of Children, 1989. This basically draws attention to look into various spheres of that particular child. His civil, political, economical, cultural, what all aspects has led that juvenile to commit an offense. All these needs to be considered when you are treating a juvenile for any offense committed by him. So this United Nations Convention on Rights of Children addresses these aspects, and it has highlighted few important points that needs to be considered as rights of a juvenile. What are those rights? The first one is right to survival. Every juvenile has a right to survival. Irrespective of his offense, he has the basic dignity or the right to survive. That's the first thing. Second one is right to protection. Right to protection includes all forms of exploitation. He should not be exploited for whatever actions he has done. So protection is the second right. Third thing is right to development. He has to be provided equal support in terms of education, health, nutrition. So right to development is the third right that was incorporated by United Nations Convention on Rights of Children. And finally, right to participation. Right to participation. Right to participation include right to freedom of thought, your religion, your conscience. He has all those right to participation. He has all those rights as well, which were incorporated in the Constitution. These are the 4 fundamental rights which has to be taken care of, even if he is a juvenile also. So now, again coming back, is India a signatory to this United Nations Convention on Rights of Children? Yes or no? United Nations Convention on Rights of Children. This is the international convention which gives some binding, which gives some recommendations to the countries to follow whatever the child rights needs to be incorporated in their regular legislation, regular course of governance. So is India a signatory to United Nations Convention on Rights of Children? Yes or no? India is a signatory member. India is a signatory member of this United Nations Rights of Convention. When you are a signatory member, you have to abide by all the rules and regulations which were put forth under this UNCRC. So you have to abide by that. What does United Nations Convention on Rights of Children prescribe? What is the age limit which was prescribed internationally? It is 18 years of age. So whoever are the signatories of this United Nations Convention on Rights of Children, they have to treat any person below the age of 18 years as a juvenile only. They have to treat them as juvenile only. But are we now on equal footings with United Nations Convention rules? Are we following that? So we are violating whatever the juvenile justice system, Juvenile Justice Care and Protection of Child Act was passed. It is treating people below the age of 16 and 18 years as adults and considering them as offenders. Why? What made India to necessitate such a change in the age criteria? What made India to make such certain changes with respect to age criteria? What? So we have brought a change. So whatever crimes were committed in India, basically they are categorized into 3 heads. One is known as heinous crimes. Second offenses are called as serious offenses. And the third one is some petty offenses. So, if you are resorting to heinous crimes or serious offenses or petty offenses, if a juvenile is convicted of any of these offenses, any of these three cases, heinous, serious, and petty offenses, in which scenario a person below the age of 18 be treated as an adult? In case of, so what do you mean by heinous crime? What do you mean by heinous crime? What is the definition? Is there any definition for heinous offense? What do you mean by heinous offense? So, if someone is committing a gruesome, horrific offense against someone, then can that be treated as heinous? So, the nature of crimes decides that offense as heinous, or the term of crime that decides heinous? It is the nature of crime. It is the nature of crime or the term of crime. As per current prevalent existing legal system, is there any definition of heinous crime in our IPC or CRPC, with whatever you consider, even if you take into account the Juvenile Justice Act also? What is considered as heinous? Is it the nature or the time period? Nature. So, as per law, basically as per law, if any offense, for any offense that was committed by any person, if the imprisonment is more than 7 years, then that crime is said to be a heinous crime. Whatever the punishment that you are getting for the act done by you, if it is heinous in nature and the imprisonment which was awarded to you was more than 7 years, then that crime is categorized as heinous crime. So, now what is serious offense? What is serious offense? So, any crime which has an imprisonment of 3 to 7 years, 3 to 7 years imprisonment. If someone is convicted for any offense with a time period of 3 to 7 years, then that offense is known as serious crime. What about petty offenses? Petty offenses means for whatever the imprisonment level is, which is below 3 years. If imprisonment is below 3 years, that is considered as petty offense. That is how the law segregates offenses under different heads based on the tenure or time period of imprisonment. So, let's say if a juvenile is convicted of a heinous crime, can juvenile be awarded life imprisonment or death penalty? Under the prevailing system, can juvenile be awarded life imprisonment or death penalty? Yes or no? As per the existing law, can he be awarded? Can he be awarded? He cannot be awarded. Juveniles cannot be awarded death penalty or life imprisonment. Only adults can be awarded. So, now again, we have something called as juvenile delinquency. Have you heard the word juvenile delinquency? Delinquency, DELINQUENCY. What do you mean by juvenile delinquency? What is the meaning of delinquency? In Juvenile Justice Act, we come across this term, juvenile delinquency. Juvenile delinquency means a person who is considered as a juvenile who is taking part in various anti-social or various criminal offences or illegal behavior which is witnessed among the criminals is known as juvenile delinquency. whatever the criminal attitude, the illegal behavior, the attacks which were committed by these juveniles is known as juvenile delinquency. In recent times, there has been a rise of crimes. The crime rate of juveniles has increased by 30% in recent times. So the juvenile delinquency rate in India is increased by 30% in recent times. Almost in all the horrific cases that we have witnessed in recent past, be it the Delhi gang rape case, the 2016 Delhi gang rape, there also we have the participation of juveniles who have committed a gruesome murder of that girl. Same is the case with Shakti Mills case, which happened in Mumbai. There also there is involvement of juveniles. So in recent times, the involvement of juveniles in these heinous crimes, or the involvement of juveniles in these cruelsome activities has increased. That is what is known as juvenile delinquency. The word which was prescribed in the Juvenile Justice Act was juvenile delinquency. So almost like the crimes, whoever are undergoing, if you consider the crimes which were reported, people who have committed these crimes, 70% of the people, 70% of the juveniles who have committed these sort of crimes were under the age group of 16 to 18 years. The pre-existing status is 70% of cases who involve juveniles under these heinous crimes were in the age bracket of 16 to 18 years. So this has necessitated the policymakers or the government to introduce or come up with this Juvenile Justice Act amendment, which was made in 2015, which has brought in a change of age limit from 18 to 16 years. This has necessitated the whole scenario for change in the age of consent of any particular juvenile. So let's say if a juvenile is convicted of any offense, how he should be treated? How he should be treated? If a juvenile is convicted of any offense, for any offense that he has committed, who is the competent authority to dispose of his case? Who looks into his, can he be tried in the normal court? Can the juvenile be tried under normal court? How can he be tried? Which court? Juvenile court. So a special type of courts called as child courts were set up, and whatever offense he has committed, that has to be examined by a body which was constituted especially to deal with offenses which involve juveniles. That is known as Juvenile Justice Boards, JJBs, Juvenile Justice Boards. So now what is the composition of this Juvenile Justice Boards? It includes who? What is the composition? Who are the members included in this Juvenile Justice Board? Psychologist. One woman. So basically it consists of 3 persons. This board is constituted by 3 persons. One person has to be a judicial magistrate, first class judicial magistrate. One judicial magistrate should be there, and 2 people should be from the fields of social workers. It can be a psychologist, it can be a doctor. So 2 are the non-judicial members and 1 member is a judicial member. And on top of that, there should be at least 1 woman member in the board. So out of 3, 1 woman member should be there compulsorily. So the composition of the board is 3 members, and all these 3 people should come together and work as a unit. They will be deciding on what is the punishment that needs to be imposed on that juvenile. So what is the maximum punishment that this Juvenile Justice Board can incorporate or impose on an offender? What is the maximum punishment? What is the maximum punishment that can be imposed on a juvenile who is tried under this Juvenile Justice Board? It is 3 years. Maximum punishment is 3 years. Only 3 years. And it also specifically mentioned that whoever is committed and whoever is offended under this Juvenile Justice Act, he should not be publicized. He should not be displayed. His name should not be revealed, or it cannot be circulated in media as well. No possibility of bail if someone is convicted of heinous offense. He has to be sent to the Juvenile Justice Boards only. Obviously, he also comes under the same treatment. Every juvenile has to be treated under the same head. Even if he is acquitted of same. The process would be the same. What punishment will also be 3 years only for if he is a juvenile. What is the difference between? What is juvenile delinquency? Whatever crimes he is committing, the number of it is an act. Delinquency means it's an act. Illegally committing crimes. If the child is included in this, he is called juvenile delinquency. Normal law. He does not come under normal law. He should not be tried under the normal law also. Only he should be tried under Juvenile Justice Act. So now, coming back to our earlier decision. Various countries. No. India has incorporated this, but various countries follow different age limits. So if you look at the global picture, what is the age limit which was put forth, which was followed by different countries? In England, for several offences, children above the age of 10 are held criminally liable. In UK, people who are above the age of 10 years are criminally liable in UK, but that is not the case in India. Same if you take into account Australia, the prescribed age is 14 to 18 years of children. They can be held with some criminal offences. Criminal law, they can try people between the age of 14 to 18 under criminal law in Australia also. And if you look at United States, people above the age of 12 years can be treated with criminal acts, can be treated for criminal acts, about 12 years in US. And if you take into account the southern nations like Bangladesh, in Bangladesh also it is 16 years. People above 16 years can be treated with a criminal law. And in Denmark it is 15 years. This is the global scenario which is followed. So these are the countries who follow below 18 years of age, and they try them as under the criminal law. But that is not the case with India. Yes. Reduce the age to 16, but even 16 years child cannot be coming under the criminal law, official criminal law. He has to be tried under juvenile law only, not criminal law. That's the scenario. So now, again, how a juvenile is treated if he is convicted of the offense? What is the process in which he has to undergo? If you look at the Juvenile Justice Act, there is something called as Section 15 of Act. Section 15 of Juvenile Justice Act. It specifically mentions Section 15 of Juvenile Justice Act. It specifically mentions that child who is above the age of 16 years, if he has committed any heinous offense, the Juvenile Justice Board is required to undergo a preliminary examination for his conduct. A preliminary examination has to be undertaken by the Juvenile Justice Board if a person who has committed any offense who is above 16 years of age under Section 15 of the Juvenile Justice Care and Protection of Children Act. So what all needs to be taken into account when you are examining, when preliminary examination is going on? What all needs to be considered? Obviously, his mental and physical state of mind, that needs to be considered. Next, his ability to understand the consequences of the act. Ability to understand the consequences, whether he is in a situation to understand the consequences. And also, what circumstances that made him to commit or alleged to commit such an offense. What are the circumstances that has made him to commit such an offense? All these three has to be taken care of under this section 15 of Juvenile Justice Act. This preliminary examination has to be undergone. So what is the time period when this preliminary examination is initiated by the Juvenile Justice Board? Is there any time period? Within certain time period they have to come out with whatever recommendations they want to make? So there is a time limit. Whatever preliminary examination or inquiry is initiated by the Juvenile Justice Board, that board has to come up with a report, and final judgment has to be given within 3 months from initiating such proceedings. Within 3 months it has to be disposed of for whatever offense he has committed. Evariki? Criminal is not at all in the context. For whatever acts he has done, examination అనేది జూనైల్ జస్టిస్ బోర్డ్ చేస్తారు. జూనైల్ జస్టిస్ బోర్డ్ అంటే it consists of again 3 members. They will be inquiring what made him do that. So the time period is 3 months. So again, there is something called as CARA. It stands for, under this Juvenile Justice Care and Protection Act, you have to establish or set up CARA. CARA stands for Central Adoption and Resource Authority. Central Adoption and Resource Authority. It is the competent authority who have to take care of all the children's rights. So this CARA has been provided a statutory status by this Juvenile Justice Act of 2015. When Juvenile Justice Act was amended, this CARA was granted a statutory protection. When you are granting statutory protection, obviously it is binding on the body to take care of all the rights of children. All their occasional training, their health, nutrition, all these have to be met or borne by this particular authority, Central Adoption and Resource Authority. They have to take care of all these things. So the law itself is imposing certain obligations on this particular authority to take care of the rights of the children by granting statutory status to this particular body. This body is granted statutory status. So finally, so why is this in news? Because all this topic, why it came up in news is because the Supreme Court, recently the Supreme Court has asked the national and the state child right activists to issue certain guidelines, on to what should facilitate Juvenile Justice Board in conducting the preliminary assessment. So there has to be certain guidelines. You cannot say that intellectual maturity or cognitive ability of a child should be improved. In what terms this preliminary assessment is being conducted? So that guidelines for that preliminary assessment needs to be drafted by the national government. That is what the Supreme Court has directed recently, very recently, in this Gurgaon child murder case. Again, when these juveniles were brought into picture, so the Supreme Court has directed the central government to frame or come up with some rules and regulations as to what to be constituted under the preliminary assessment, preliminary examination. Those guidelines has to be demarcated or drafted. That is the whole agenda of this context of news, which came up last week. So this is regarding the Juvenile Justice Act. So now write down a mains question, like with related to this juvenile justice system. Throw some light on juvenile justice system. Throw some light. Throw some light on juvenile justice system in India. Has the system adequately evolved? Throw some light on juvenile justice system in India. Has the system adequately evolved? Has the system adequately evolved with the demands of the time? With the demands of the time. Justify. Time. All right.